Hi, guys. We are at the last presentation of the day, but it's going to be one of the best presentations. Mr. David Slayton has served as the Administrative Director of the Office of Court Administration since May 2012. That means he answers to the Chief Justice and every other judge in the state of Texas and tries to keep them happy. He also serves as the Executive Director of the Texas Judicial Council. David is the past president of the National Association for Court Management and was formerly the secretary of the board of directors of the Texas Association for Drug Court Professionals. He has been employed by the judicial branch in various roles since 1998, beginning his career in Lubbock. Mr. Slayton is a graduate of Texas Tech University and has an MPA from Troy University. I was at a child abuse conference a couple of weeks ago, and David went over the response of the judiciary to COVID. And that has been a major, major undertaking to keep the wheels of justice moving in an extremely difficult situation. So, David, thank you for being here on fairly short notice. And why don't you tell us about the judicial response to COVID?
Thank you very much, Judge Specia, and good afternoon, everyone. Thanks for letting me have a little bit of time with you all this afternoon to talk about how the judiciary has responded to COVID. As with so many things in our lives over the past many months, COVID has had a pretty significant impact upon the judiciary. And I think you'll see and join me by the end of this presentation in realizing that the courts in the state of Texas have responded in a remarkable way to COVID. And I want to just thank all of you who are on today who've had a role in that. You'll see some of that throughout the presentation today. I'm going to save some time at the end for questions. So if you have questions, I hope you'll put those in, and Judge Specia and I will save some time at the end to talk about that. So I'll take you back down memory lane here for just a moment. It seems like an eternity ago. But basically, you might recall that back in March, we began to see COVID cases in the state of Texas. The judiciary was included by Governor Abbott in the discussions about how the state was going to respond to COVID. And so we were able to begin to think about in February about how we would respond. And one thing that was really great that you all may not have seen behind the scenes is that our two high courts, the Supreme Court of Texas and the Court of Criminal Appeals, both began to say to me and others that the courts needed to be prepared for this and that we needed to do our best to make sure that justice could continue to be available for all who needed it during the pandemic. Other states' response was a little different. Some of them a little slower. Some of them shut down for the most part for several months. But one thing that was great about the Texas response, as you'll see here when we talk about it, is that the courts never really closed. It became access to justice was available throughout. Not that it hasn't been difficult, and there haven't been difficulties along the way, but I think we should be very proud. Another thing that the court said, which I thought was really incredible, was that some states had said, well, we'll just do emergency matters in person. Everything else can just wait. You might recall that at that time, we thought that this might only last a matter of weeks or maybe a couple of months. But our two high courts said that to the litigants in our Texas court system, to each of them, their matter, even if we don't consider it to be one, to them, their matter is an emergency to them. And so we really began to work to make sure that all matters could be resolved in the court system. So one of the things that we did early on was to begin to make sure messaging was out to the courts to think about how to respond. And you'll see that on March the 12th, OCA recommended that the courts suspend any in-person proceeding. And you'll see we actually said that to do that until April 1st. Obviously, looking back now, it almost seems comical, but we thought that perhaps just a couple of weeks delay might resolve this issue. Obviously, as we're seeing even today, the issue continues to be a major significant issue for the courts, and we've continued to limit in-person proceedings. On March the 13th, this shows how well prepared the two high courts were. On March the 13th, the Supreme Court and the Texas Court of Criminal Appeals issued its first emergency order. I'd like to point out that this was done within 4 hours of the Supreme Court receiving its emergency powers after the governor declared a disaster. So the governor declared a disaster around 1 o'clock. The Supreme Court and the Court of Criminal Appeals issued the first emergency order 4 hours later. Pretty impressive, showing that their response is they were on top of it. And they did a number of things. They allowed for remote hearings. They allowed for court judges to handle hearings remotely from the courthouse. They allowed for other types of protections to be in place, all the time realizing that the need to balance the access to justice issue with the right for people who are being called to court to be kept safe, their health and safety to be kept safe. And so on March the 13th, that was issued. And the primary thing that I'll focus on today was the ability to conduct hearings remotely. And just about a matter of about 10 days later, the courts in Texas began using Zoom as its platform, primarily using Zoom as its platform to conduct hearings remotely. We were the first court system in the country and the world to actually do this. And so, again, we should be really proud. But 10 days later, judges all over the state were holding hearings. And even during that 1 week in between, there were judges who were testing it. So pretty much the courts never really skipped a beat from the perspective of the ability to provide access to justice remotely. On May the 4th, OCA issued and the Supreme Court issued an order concurrently with that guidance for how in-person hearings could occur. To be clear, to this day, still, the Supreme Court's order says that courts must use all reasonable efforts to conduct hearings remotely. And so everybody from the municipal courts, justice courts, district courts, appellate courts, the court's order requires them to use all reasonable efforts to do things remotely. And we'll talk a little bit about why that is as we go throughout the presentation. But on May the 4th, we issued guidance starting June the 1st that allowed some hearings to occur in person if it couldn't be done remotely. And again, focusing on the need to keep the public safe, we put in that guidance, public health recommendations, things for courts to think about with regard to doing that safely. And knock on wood, I'm proud to say that to this day, I'm not aware of a single incident in the state where an outbreak has been related back to a court proceeding. Our judges have done a really good job in making sure that they're able to provide those in-person hearings that must be done that way safely. We'll keep hoping that stays the same. On May the 8th, in our state, we had our first fully virtual jury trial. This was the first fully virtual jury trial in the country, in the world. So again, Texas leading the way. And that was in a civil case held in Collin County. Every participant, including jurors, appeared remotely and was able to have that case heard fully virtually. On May the 27th, the Supreme Court issued an order prohibiting any sort of jury trials to be held in person through August 1st. That date was later moved to October the 1st. And basically, they required OCA to work with a number of judges across the state to have a limited number of jury trials so that we could learn how to do that in person. As you can imagine, gathering together 100 people or more into a single room during the midst of a pandemic is a challenging task. And so we worked with a number of judges across the state to figure out how to do this. And our first in-person jury trial was held on June the 18th. Throughout the summer, we worked with a number of judges all over the state to hold both in-person and virtual jury trials. And on August the 28th, we issued a report, which is available on the txcourts.gov website, that lays out recommendations to the Supreme Court on how to go about handling jury trials during the pandemic, all based upon information that we learned from judges' experiences throughout the summer. I would point out one date here is missing, that in mid-August, we actually had our first virtual criminal jury trial. A justice court in Travis County actually held a traffic case, which is a criminal case in Texas, held that fully virtual, and it went off without a hitch with everyone, including the jurors, appearing remotely. On September the 18th, the Supreme Court issued the 26th emergency order. And what that order did was permit jury trials to begin starting on October the 1st for district and county courts with certain criteria and plans being in place. And we'll speak about that later on in the presentation. So it's been this is just some of the highlights. There's been obviously a lot more behind the scenes going on, but you can see a lot of work from the very early times all the way up until today, working on how to do this safely and provide access to justice. Just another thing that you should see, just to kind of give you some insight on how we've seen the use of remote technology increase. Over time, this is a graph that shows you month to month the usage of Zoom through our licenses that we provided to those judges. There are some jurisdictions that are using their own, so this doesn't capture all of them, but certainly captures the majority of them. You'll see that from March to the end of October, from every month, the number of remote hearings being held remotely has continued to increase. And actually, as of today, over 650,000 hearings have been held remotely using the OCA Zoom licenses that we provided to all of the judges. That number, as I said, continues to increase. Almost 2 million participants in those hearings during that time, and over 1.6 million hours of hearings. So it is interesting when you can see it from my side of things, looking at the dashboard, that you might think, well, then some judges must be using this a lot. It's really interesting to see that in actuality, a lot of judges are using it a lot. It's pretty widespread. And so every type of hearing has been used this way, and it's been done very successfully. So what have we learned during the pandemic with regard to remote hearings? One is that we've been able to use remote technology to have hearings in cases in every hearing and every type of case. Not to say that it's the best way to do every hearing and every type of case, but we've seen judges in every type of case and every type of hearing be able to do that. And so I think that shows us that, number one, we can continue doing that, but then number two, we can begin to think about what might happen in the future, and we'll talk about that shortly. We've also found that virtual jury trials can work. Again, is it the best way to do jury trials? That's still probably out to be determined, but we can do it. In fact, we've seen some jury trials already. We've seen 3 jury proceedings occur already, and we have 3 scheduled next week, just to give you an example, and probably 8 to 10 in the next month. So we're seeing courts all across the state embrace this. What you'll see later on in the presentation is that our perspective on this has been virtual jury trials may not be the right option for every case, but it has to be an option on the table during the pandemic because of the challenges we're having with being able to do jury trials in person. Another interesting thing that we've learned from doing hearings remotely is we've seen increased participation. Most of you who work in the courts know that when you schedule a court hearing, oftentimes people who are scheduled to appear don't show up. So in a criminal proceeding or a traffic proceeding or other type of case like that, if the individuals don't show up, of course, a warrant is issued for their arrest. And child support in hearings, a lot of times people don't show up for those child support enforcement hearings, resulting in defaults and evictions, and just keep going on down the road. Child welfare cases, CPS cases, parents and families not appearing as required. What we've seen is an interesting phenomenon, and this is not just a Texas phenomenon, that really with remote appearances, we've seen a significant uptick in the number of people showing up. In fact, some judges have reported to me that in the last several months, they've had 0 people miss their court hearing. And for those of us who have been working in courts for some time, that is quite unique. I think what it shows that those individuals who are being scheduled for court hearings, they might be showing up from the Walmart break room where the person was working, or from the side of the road if they're a trucker that's driving, or in the bedroom with their children outside being watched by another adult in the other room. What we've seen and what it seems to show is that the remote technology has removed barriers from people being able to participate in their hearings. So much so that many judges have had to reconsider how to schedule their hearings just to make sure they can accommodate the larger number of people showing up. So that's a really positive outcome, as all of us who work in courts know. The worst case scenario is people not showing up and participating in their case. So of course, seeing that increased participation has been a very positive outcome. We've also seen a lot of judicial efficiency. Again, I don't want to paint with such a broad brush to say that it's always more efficient, but we've seen a lot of improvements in efficiency in a lot of areas. One is that it's just a sort of simple example. Many of our judges, many of you probably on here, actually travel to cover large areas of geography in the state, having multiple counties. One of our judges reported to me that he is saving 4 hours a day in travel time just simply because he's able to handle the proceedings remotely without having to travel. We've seen judges become very efficient in handling status conferences and other types of docketing that is actually more efficient than doing it in person simply because of using remote technology. So that's been a really remarkable thing. We're actually looking to do a study to verify where we're more efficient and where we're not. And so we'll have some data on that hopefully next year. The other thing I would say that's been interesting to watch is how it has provided increased access to justice. As you all know, they've been around the justice system for a while, making sure that people have access to lawyers, access to interpreters when they have limited English proficiency, and access to court reporters to take the record. These are oftentimes major challenges faced by courts across our state, and especially in our rural areas. And of course, the advent of remote technology has allowed those individuals to appear remotely. So, for instance, a lawyer can be sitting in their office in Fort Worth and handle a pro bono case several hours away in another county. Instead of traveling several hours to get there for their 15 or 30-minute hearing, they can be at their office working on a case and at the same time appear remotely and handle that case in the other jurisdiction. Interpreters, we've seen an 80% increase in OCAs, Spanish interpreters that we have on staff providing services. And then the court reporters have reported a significant uptick in their usage by remote technology. So I think it's been really great to see that increased access to justice. The other two things that are important to note is that we've seen an increased need for technical staff. I don't think all people who are on the bench, for instance, ran for office on a platform of being really technically savvy and being able to run a Zoom meeting really well. And so we've had to see them have to increase their technical competence as well as their staff doing that. Many times a judge is needing to focus on obviously being a judge. At the same time, perhaps they need someone from the court staff assisting with the technology. And then lastly, that we've seen that assistance requires sometimes the need to help assist litigants in being able to use the technology. Remarkably, we've not seen a significant issue in people being able to access and use the system and participate remotely. As I mentioned, increased participation, but there are still times where someone doesn't know where the unmute button is, or they can't figure out something else. And so those things are very important for us to keep in mind. Another interesting thing that we've seen is the impact of the pandemic on actual just cases coming through the court system, and this just provides some high level trends looking at from March to August. Obviously, September and October data are still being computed, but as you can see, the number of filings in our major case categories have declined quite drastically during the pandemic. And while that is coming back some, we still are seeing pretty significantly decreased filing volume coming into the courts. At the same time, we're, of course, seeing decreased disposition rates as well. And as you can see here, civil is the exception to where civil is actually, this number is actually better than it was pre-pandemic. So judges are able to move more cases from that perspective than they did in the past. But in our other case types, we are struggling. And the courts are beginning to pick up speed on that and being able to move those cases more efficiently. But it has been a pretty significant impact on that overall. We'll turn our attention now to jury trials and spend the rest of our time here this afternoon talking about jury trials. Just to put this in perspective, I know many of you may or may not know this, but everyone, when they think about courts and cases, they always immediately go to a jury trial. In Texas, we disposed of over 8 million cases in fiscal year 2019 prior to the pandemic, and only 0.5%, half a percent of those cases were resolved with a jury trial, which means 99.5% of the cases were resolved without a jury trial. So they were either dismissed, or there was some sort of settlement or plea agreement, or some other resolution that came up. So, the one key message here for everybody, especially those of us in the court system, is to focus a lot of our energy and attention on other stuff besides jury trials. But that being said, we all know that the jury trial proceeding has been a hallmark of moving other cases. So we've got to keep our attention on that too. So focus on the other stuff, but we've got to put our attention on jury trials as well. Just to give you some perspective, again, in a regular year, in a normal fiscal year, last fiscal year, Texas would normally tries 186 jury trials every single week. Between March and the end of September, we tried 45 total. 186 weeks down to 45 over that entire period, simply because of obviously the ability to do that being limited. So what that means is that just counting those months between March and then in September, we're behind about 5,500 jury trials in the state. 3,300 of those are for jailable criminal cases, and the rest are for other types of cases, civil and family and other types of things. So obviously a pretty significant backlog. The other thing you should know is that what we're seeing, and you'll see some of this in a minute, is that probably going forward that we're going to be limited to maybe 20 to 30% of our capacity of trials per week, which means we have a backlog, and that backlog is likely to continue to grow, which is again the reason why I'm saying every type of option should be on the table for trying to resolve jury trials. So again, jury trials have been suspended until October the 1st. OCA was directed to assist the trial courts in getting a limited number of jury cases tried so we could learn from that. You'll see on the slide here that we actually had 97 requests for jury trials from judges across the state. 96 were approved. There was not one unfortunate soul who was denied. One judge, after discussing it with us, decided to withdraw that request. So pretty much everybody who requested to try a case was approved. Of those requests, 34 of those were civil and 63 were criminal cases. We ended up starting 50 jury trials. 45 of those cases went to verdict. 20 of those cases were civil and 25 were criminal. And we had the remainder of those five. One of those four, one of them was a mistrial, and 3 of them were either pled or settled after the jury was seated. So I mentioned to you earlier the impact of the 45 cases. You see here where those were, and they were spread in large, small, medium-sized counties. Really, a lot of folks across the state spent a lot of effort, and I will at the end we'll put in the chat a link to a video that you can go watch and see how some of the jury trials were occurring around the state. I would encourage you to take a look at that so you can kind of get a grasp of how that's working. But it also profiles several of the judges in the state who worked very hard to be able to pull this together, and we are grateful to them. So with the information we gained from them and their trials across the state, and working with them and the state health authorities on what the best practices were to provide access to jury trials in a safe way, OCA developed a number of jury trial requirements. We made these recommendations to the Supreme Court, and the Supreme Court ultimately adopted those for use in all courts across the state. So we'll spend a little time talking about what those are. The first thing is that in-person juries are limited to only district and county courts between October 1st and December the 1st. And so for the next several weeks at least, since October the 1st, only district and county courts have been able to hold in-person jury trials. The Supreme Court is likely to look at that and issue a new order that will provide guidance going forward past December the 1st. just pause here to tell you, because some people have asked, why don't they, give us longer direction? The Supreme Court's authority to issue emergency orders is limited to 90-day increments. So no order is going to extend further than 90 days. And this order was pretty close to 90 days that was issued that expires December the 1st. So just because you see December 1st doesn't mean that means things are going back to normal after that. It just means that is the extent of their order, and you should stay tuned for any further orders from the court on what's going to happen after December the 1st. But for now, at least, jury trials limited to district and county courts. Go a little out of order here on the slides, but each, in order to have a trial, jury trial, in-person jury trial in those counties, each county has to have a plan that's provided by the local administrative district judge. So each county has a local administrative district judge. They develop a plan for how they're going to do in-person jury trials. We provided a template and some guidance to them from the Office of Court Administration, but that plan is something that they get to develop locally, speaking with their judges, with their local public health authority, with others in their community. But basically, that plan sets out how they're going to go about conducting jury trials. We'll talk about some of the components of that in just a minute. Once a plan is in place, a individual judge can hold a in-person jury trial if they get approval from their local administrative district judge and their regional presiding judge. The purpose of that is really, so we've got the plan in place. Many times those plans are going to talk about where it's going to occur and how many on this floor or that floor of the courthouse. And so the purpose of getting approval from the local administrative district judge or the regional presiding judge is to really try to control the capacity. We know that many trials now are taking multiple courtrooms, they're taking other buildings. So making sure that we have no issues with scheduling is really important. So basically, that's where the approval process comes in. In addition to that, the local administrative district judge is charged with staying in contact with the local public health authority. As cases go up and down around the state and different counties, the Supreme Court really wanted this to be a local decision as to how this would go. So the consultation with the local public health authority lets the local judges know whether or not their plan is sufficient based upon the health situation on the ground. And it doesn't have to be a statewide push from that perspective. So they're required to consult with the local health authority not more than 5 days before trial, just to make sure that there's no big red flags that should stop the trial. And certainly that has happened even since October 1st in the state. So I'll go back to the two bullets in the middle here, just to say that once that trial is approved, once there's a county plan approved, once there's a trial approved by the local administrative district judge and the regional presiding judge, and once the health authority gives the green light, then of course that trial can proceed. There's two things that are important in the Supreme Court's order, though. One is that if there are any motions filed or objections made to proceeding, then the judge is required to hear those objections on the record. Obviously, there are some litigants and attorneys and others who may have some motion or some objection to proceeding right now during the pandemic. And so the Supreme Court's order requires that to be done at least 7 days before the trial begins, if the motion or objection has been made, at least 7 days, and then as soon as practicable if it's made less than 7 days before trial. Judges on the webinar here, you can order deadlines that are 10 days in advance, so you'd have that. But basically, if you don't have a deadline that you've put in place, it's got to at least be heard 7 days in advance or as soon as practicable. What that does is provides an opportunity for the attorneys or litigants to make their case as to why they shouldn't proceed. And then, of course, if they are unhappy with the ruling, they could seek any sort of appellate review in time for the trial. In addition to that, the Supreme Court's order permits virtual jury trials to occur in the state. And that's at all levels of court, from the justice courts, municipal courts, all the way up to the district courts. The only exception to that is one, that if it's in a jailable criminal case, there has to be waivers and consent from the defendant to proceed that way, and from the state. But and then also, if there are any motions or objections to proceeding that way, those also have to be heard on the record, similarly to the other in person. So as I mentioned to you earlier, we are seeing courts begin to do in-person jury trials. We're also seeing courts begin to do virtual jury trials. And then we've also got a few that are doing a hybrid where they're picking a jury virtually and then having the trial in person. So again, I think our key message has been, we want to make sure that all options are on the table. That way, perhaps there's an in-person jury trial going on, a virtual trial going on, a hybrid trial going on. It just gives us the ability to dig into some of that backlog a little more. Let's talk a little bit about some of the guidance that's in the jury trial requirements, and we'll spend the rest of the time talking about some of these specifics. And again, I'll just remind you, these messages came from the ability to observe a number of jury trials throughout the summer and talking with state health authorities, local health authorities, observing courts and seeing what worked and didn't work is how we came up with all of these. The first thing is there's a requirement in the guidance that courts really look into the way they're summoning jurors. So for a long time, OCA has put out the model jury summons language, which is obviously just provides the very basics of that. And our guidance here says that the judges should include some specific language in their jury summonses. As you can imagine, there is some hesitance by members of the public to show up to jury duty. And we've been concerned all along about making sure that a representative pool of jurors show up to jury service so as not to affect the rights of individuals of having a jury of their peers or representative venire. And so one of the things that we've found that has worked really well is, one, including with the summons a letter or some other information that shows jurors exactly what steps or generally what steps the court has taken to keep them safe. What we've seen in reality is that when jurors show up to trial, they're very happy with the steps the courts have taken. And we've gotten letter after letter after letter from jurors who say, I really felt safe here, felt safer here than I did at the grocery store or church or anywhere else. And they didn't feel like we were taking this lightly. So giving them that information, we've seen that has impacted the number of jurors who'll show up. We also recommend here that judges include with that what we call the COVID questionnaire. And it's the things that you're probably used to if you've gone to the doctor or you've gone anywhere else, where they ask if you've been exposed or have symptoms or if you are in a vulnerable population. And what that does is it allows the court to gather that information in advance so that individuals are not showing up for jury service that have been exposed to COVID or have COVID or might have special circumstances that might make them especially vulnerable. In those instances, the courts can take that information and then choose whether or not to have those jurors appear or to excuse them or to defer them to the next year, for instance, things like that. So that's what we do with the summonsing process. The second guidance really talks about the location of the trial. To be clear, I've talked to many, many judges over the past several months. There are very few courthouses which have the space for jurors to appear for jury service in the normal courthouse building where they've always appeared. One thing's for sure, courthouse space is a precious commodity. And so for years, we've designed our courthouses and our courtrooms just big enough to accomplish what we need to. Unfortunately, we did not build them with social distancing in mind. And so most of our courthouses are not equipped to do this, to put 100 people together, for instance. And so what we've seen happening is courts using other buildings, perhaps that are owned by the county, or other facilities in the community, like a community center. You see the picture here. This is actually a convention center that one of the judges used. Ballrooms, gymnasiums, theaters, all of the above in the community to try to find enough space large enough to be able to bring jurors together to pick a jury for a jury trial. So again, we're recommending that courts think about that as well. The courts will also need to think about other locations, such as where is the jury going to deliberate? Most of our jury rooms, again, are built just big enough. They're not large enough for jurors to be able to socially distance during the deliberation phase. So maybe that means, and what most of our courts have had to do is use another courtroom for that. Where's the public going to sit? So all these type of things become an issue that you have to really think about. Not impossible, but something to think about. Screening, obviously, the typical screening that we're seeing everywhere we go is recommended here as well. Screening people for symptoms of COVID, temperatures, those type of things are obviously really important for every person that's going to be in that room. We know, based upon the health authorities' information to us, that the spread is more. There's a higher risk of spread in closed facilities. So obviously, a courtroom being a facility where people will be sitting for some period of time, we want to make sure we're screening for that. With regard to face coverings, we've spent a lot of time on this, working with the local public health authorities. And in a jury trial, this is a particularly big challenge because jurors who are being questioned to be considered to be picked for the jury, and witnesses who are testifying in particular, the lawyers and the judges generally want to see their face. Because that helps with judging credibility and other types of information. So one of the things that's been really interesting is to have a discussion about how do we do that. So basically, the state health authorities' recommendation to us, understand that issue, is, of course, having everyone wearing a face covering at all times, except that when they are speaking, they could pull down their face mask as long as they're wearing a face shield. So that's the plastic you've seen. So many of our courts have purchased face shields. They're providing them to all jurors, to the witnesses, and that allows them to remove their mask for short periods of time to answer the questions that are being asked by the attorneys or judges or whoever. So that guidance is in our information, and we certainly have done a lot of work on that with others. Obviously, social distancing, that is difficult in a courtroom. Again, space is a premium. And so making sure jurors are equally well spaced in the courtroom, or witnesses, attorneys during the proceeding, really got to think about where everybody's going to go. And I've seen a lot of judges drawing maps with little 6-foot circles around the individual, but that's part of the challenge here of making sure that can happen. We also are recommending that judges really think about alternative jurors. If you go through all the trouble of picking a jury, you don't want to lose your jury because somebody had a car wreck or heart attack. If someone comes up with COVID, you're probably done anyway because of the fact that there probably been people who have been exposed. But if there are other types of things that happen, which they oftentimes do, it's important to have alternates in place so that the process doesn't have to start over. Courtroom arrangement is a really important thing to think about. Again, where's the jury going to sit? Most courts have had to move their jurors to the gallery of the courtroom where the public would normally sit, which may mean you need to move the witness closer. You may need to think about the screens that would normally be used with evidence and things, where those go. So really kind of thinking through where everybody's going to sit, which way are the counsel tables going to face? Are they going to face the judge? Are they going to face the jury? All things we're thinking about that we address in our guidance. Microphones are another big consideration, is to make sure that we take care of that. One of the things that we learned during the time was making sure that when someone's speaking and when they might deposit, if they happen to have the virus and they deposit it on a microphone, another person that's close to a microphone could inhale that. And there's really no way to clean those effectively. So we suggested microphone covers for people to use, and try to limit microphones to not use them when you don't have to. With regard to exhibits and evidence, obviously, we're trying to figure out a way to keep people from touching, everybody touching and passing around evidence. So we're encouraging folks to limit that as much as possible, making evidence and exhibits digital so that they can be shown on screens. But obviously making sure you're thinking about where are the screens and can the jurors and others see that is really important as part of that. When exhibits and evidence are used, we recommended that jurors or others be given gloves, single-use gloves, basically put them on, pass around the thing, and then take the gloves off and throw them away, because obviously we all have a tendency to want to touch our face when we have gloves on. So that's what we do there. Another big thing we learned during the summer with this was to really think about vulnerable witnesses. We talked about vulnerable attorneys and parties and others, and then we had a trial where we had a couple of witnesses who were especially vulnerable, going through cancer treatment and other things, and they were very concerned about appearing in court. And so it really blew up a trial that was trying to occur. And so we're encouraging you to really think about vulnerable witnesses who might be participating, getting the attorneys to inquire with their witnesses to make sure they're not in some vulnerable population, and then trying to make accommodations where possible, either allowing them to testify remotely or allowing them to just show up for a short period of time before they're supposed to testify rather than being exposed for lengthy periods of time. The last couple here are fairly obvious. One, many times we feed jurors. We're trying to remind judges pizza is not probably a good idea, or single salad bowl. We want to have individually boxed lunches for them so that they are not having to share the same food. And then, of course, remembering to spread them out during the time they're eating. And then lastly, cleaning. Cleaning's been a big issue all along with courts trying to make sure our common areas are regularly cleaned. But especially in jury trials, it's important to remember that if jurors, for instance, let's say the jury is seated and then there's a shuffle and everybody has to move somewhere else in the courtroom, that's going to be cleaned in between there. Or between every witness, when a witness is on the witness stand and another one comes in, you're going to have to clean between those witnesses. So really thinking about that is important, so to make sure that basically that's addressed. So the question then becomes, I think, where do we go from here? And what are we looking at? I have the privilege of having been appointed by Governor Abbott to serve on the state's task force on infectious diseases. And we had a meeting a couple of weeks ago about what the current status of the pandemic was and information about the vaccine. And basically, the answer is that from the data and from what we're seeing is it's likely that the effects of the pandemic will go on for some time. You all know that the number of cases in Texas is increasing. The number of cases around the country are increasing. And it's not just in our urban areas anymore. It's in our rural areas as well. Hospitalizations are up. And so it's not, despite the fact that we all have a little bit of COVID fatigue, it's important for us, especially in the courts, where we bring together more people than any other government agency or entity. And they don't come voluntarily many times. They're coming because we order them. Important to make sure, because we're making them come, that we do everything we can to keep them safe. With regard to the vaccine, it looks as if, obviously, we got promising news yesterday, which we were actually expecting. And the timeline from CDC and the state health folks is that we should expect that some people will be able to get that vaccine fairly soon, but those will be emergency workers, healthcare workers, others that are regularly exposed to this without ability to socially distance. The timelines look as if probably midsummer next summer, the general population will start getting the vaccine. And so the bottom line here is we're likely to be facing this challenge for a number of months. And so thinking about ways to safely provide in-person or remote proceedings, as well as providing safely jury trials, is really important. The other thing I would say is that once we do eventually get out of this pandemic, and Lord hope it comes fast, once we get on the other side of this pandemic and can return to more normal, what we do know is that we've learned a lot from this pandemic about what can be done after the pandemic. And so I think you'll see us looking to try to make sure that we continue to use the things that have been very positive. So for instance, one of the most common comments or questions I get from judges are, please don't take away our Zoom licenses. We've found them to be very effective. And I think that's something that we know. And so we expect remote proceedings to continue after the pandemic as well. So we'll learn more from that. Maybe we'll learn that virtual jury trials work really well in certain type of proceedings and continue that. We appreciate all the work that you all are doing. And so with that, I'll turn to see if we have some questions. Judge Specia, I think some questions have come in maybe.
David, I think you addressed the question on what we'll do. We probably don't exactly know what we do, but the judges really want to continue some parts of Zoom and perhaps efficiencies. We've gotten a 10-year education in about 7 months on that. There is a question about whether OCA will provide recommendations to the next legislative session for a mental health funding to the counties.
Yeah, I mean, of course, the Judicial Commission on Mental Health has been very engaged with all issues mental health for the last couple of years, and I will just add my kudos, which I know probably have already been expressed many times, to the commission, commissioners, the staff of the commission, Judge Specia as its jurist in residence, in really looking at this holistically. And we have a number of recommendations from them that the Texas Judicial Council, which is the policymaking body for the branch, has endorsed and is going to be pushing to the legislature. But one of the things that I think is really important and raised by this question is the need to make sure that there are adequate resources for mental health funding available in the communities. I just had some conversations last week with some legislative members about the fact that we need to make sure that there are adequate outpatient services available. Right now, a lot of our services get used up inpatient beds, and we focus a lot on inpatient beds. But as we all know, those are some of our most expensive beds. And so making sure we provide adequate funding for outpatient and making sure those services are available. I think another interesting thing that we should really be looking at is, what did we learn from the remote technology phase of this that we could use in mental health, getting assessments done more timely and things like that. I remember we did a video a few years ago with small Montague County in north central Texas that was using iPads to do remote assessments for mental health issues in the jail, and it worked remarkably well. So, now that we're getting more connected and we have more jails connected, more other places connected, we need to make sure that we can use that in ways and be creative in ways to deliver those services. But I think the bottom line answer is yes, we'll be making sure that the legislature understands the needs of the communities, especially when it comes to dealing with individuals who have mental health issues in the court system.
Are there any other questions? You can place it in the chat if there are any other questions for David.
And while we wait, I'll say one more thing, which is to say thank you to all of you that have worked very hard over the last several months on trying to make sure that access to courts could continue, whether it's a probate court, a county court, a district court, a municipal court, JP court. Don't want to leave anybody out here. Every single judge, their staff, their court reporters, jail personnel. It's been a Herculean effort, and I think we as Texans should be very proud in the way that we've responded in providing access to justice. It's really remarkable. The world has been watching us, and it's been kind of fun to sit and watch and share that information with folks all over the state. I would just add that if you have any suggestions or questions or issues, I hope you'll reach out to us. We've set up a specific email address for those. It's coronavirus@txcourts.gov. So if you have a question or an issue that comes up or a suggestion, I hope you'll reach out to coronavirus@txcourts.gov. Judge Specia, anything come in?
No, I think we may have worn them out at the end of 2 days. David,
thank you very much.
Thank you very, very much for being here, and thank you for the work that the OCA has done. It has been extraordinary, and I know that the judges across the state have appreciated the effort of OCA in this area, and we are looking forward to a very difficult session. We're going to all have to work hard to get anything done this session. So I'm going to now introduce a good friend of mine who is going to close out the conference. I'll have a couple of words after that. I'd like to introduce Justice Bill Boyce. He served as a judge on the 14th Court of Appeals in Houston for 11 years. He's now a partner with Alexander Dubose and Jefferson. Justice Boyce is a member of the Texas Judicial Council, vice chair of the Judicial Commission on Mental Health, member of the Supreme Court Advisory Committee, an elected member of the American Law Institute, an executive committee member of the Garland R. Walker American Inns of Court, a past adjunct faculty member at the University of Houston Law Center, a longtime member of the State Bar of Texas and Houston Bar Association's appellate practice sections, and a frequent CLE speaker. And he was very involved in working on legislation in the last legislative session. So at this time, he has pre-recorded remarks, and I'm going to ask for y'all to cue up the pre-recorded closing.
On behalf of the Texas Judicial Commission on Mental Health, I want to thank all of our presenters, our participants, and our commission staff for the tremendous effort that went into presenting and putting on this summit. We have some 1,200 registrants for the summit, including at least 150 judges and 260 attorneys in the middle of a pandemic. I think that's quite an accomplishment. It's also a testament to the dedication that everybody in this program has to finding solutions. Since its launch, the Commission's scope and its activities and this summit have grown exponentially. But that growth is anchored in this concept: a recognition of the importance of working across disciplines to create statewide strategies with the sequential intercept model as our common language. Another anchoring concept is this: start where you are, look for improvements, gather the data, see where it leads you, and don't let the perfect become the enemy of the good. The expertise and practical experience represented at this summit is only made more powerful as we reflect on the messages of our keynote speakers and incorporate into our efforts knowledge of adolescent brain and psychological development and implicit bias. If you're looking for an encore to the summit and an opportunity to continue the dialogue, let me recommend that you register for the 2020 Texas Tech Mental Health Symposium, a virtual conference that is organized and hosted by Professor Brian Shannon and will be occurring on November 20th of this year. Finally, we hope you will take the information and the perspectives that you've gained from this summit, apply them in your own programs, in your own experience, and come back to the next summit and tell us how it works. Again, thank you for your participation.